Picture this. You have had your green card for 6 years. You have crossed this border dozens of times. You know the drill. You know every line, every kiosk, every officer. You fly in from a family vacation. You walk up to the CBP booth, confident. And then the officer looks at you and says 5 words that change everything. Step aside for secondary inspection. Not because you have a criminal record, not because your green card expired, because you refused to look at a camera, because you covered your face, because someone on a WhatsApp group told you that the new facial scan at the airport is optional, that it's a privacy violation, that you can just say no, and now you are sitting in a secondary inspection room. Your family is waiting at baggage claim. An officer is running your biometric file. And the next words you might hear are, "You are being referred for expedited removal proceedings." I need you to understand, that scenario is not hypothetical. It is happening right now, in March 2026, at airports, land borders, and seaports across the United States. Roughly 18% of lawful permanent resident entry denials this month are directly tied to biometric non-compliance. My name is Saqib. This is Global Immigration Updates, and today I am going to give you the legal truth about CBP's new mandatory facial recognition rule before it blindsides you at the border. Here is exactly what we are covering today. Number 1, the actual federal law that made facial scans mandatory for green card holders as of January 15, 2026. Number 2, the 4 deadly traps that are getting permanent residents detained and removed right now. And number 3, your complete legal shield strategy, what to do at the kiosk, what to say to CBP, and how to fight back if something goes wrong. Do not cross any U.S. border before you finish watching this video. Before anyone in the comments says, "This is fear-mongering," let me shut that down with one document. What you are looking at right now is the Federal Register, Volume 91, Number 8, published January 10, 2026, the official legal journal of the United States federal government. And right here, in black and white, is the rule that every green card holder in America needs to understand before they travel. The rule is grounded in INA Section 303, codified as 8 U.S.C. Section 1365B, as amended by the Border Security Enhancement Act of 2025. Congress passed it, the President signed it, and CBP deployed it at every single U.S. port of entry, air, land, and sea, effective January 15, 2026. What does it require? It requires all lawful permanent residents, that means every green card holder, to submit to automated facial recognition biometric scanning when entering the United States. Your live image is captured at the kiosk or CBP booth and matched in real time against the photo on file from your Form I-551. If the match fails, or if you refuse the scan, you do not clear customs. Full stop. And look at this. 8 CFR Section 235.1F. This is the federal regulation that gives CBP officers the power to trigger secondary inspection and expedited removal proceedings the moment you refuse or fail a biometric check. This is not discretionary. This is not negotiable. This is the law. In March 2026, approximately 18% of all lawful permanent resident entry denials are directly linked to facial recognition non-compliance. That is nearly 1 in 5 green card holders being denied entry, not for criminal history, but for refusing a camera scan. Now let's get into the 4 traps that are causing this, because each one is more dangerous than the last. I have 4th Amendment privacy rights. The facial scan is voluntary. I can refuse it and CBP cannot penalize me for it. That is the myth. Here is the brutal reality. The 4th Amendment does not protect green card holders from mandatory biometric screening at U.S. ports of entry. Federal courts, including in ACLU versus CBP 2025, have ruled that facial recognition at the border constitutes a minimal intrusion legally equivalent to fingerprinting. Refusal is treated as non-compliance with a lawful CBP order. You will be sent to secondary inspection. You may be denied entry. Here is why this trap is so dangerous. Before January 2026, the thermal and biometric checks at many ports were advisory, optional in practice. People got used to skipping them. Community groups started spreading the idea that you can always say no to a scan. That information is now outdated and legally lethal. The court in ACLU versus CBP 2025 said clearly, border entry is a government-controlled checkpoint. LPRs, Lawful Permanent Residents, do not have the same Fourth Amendment standing as U.S. citizens at ports of entry. The scan is not a search. It is a verification requirement, and refusing it is the same as refusing to show your green card. Green card holders, your LPR status does not give you a constitutional opt-out from biometric entry requirements. Temporary visa holders, H-1B, F-1, J-1, all of you, this applies to you even more directly. You have even fewer constitutional protections at the border than LPRs do. People think that if the facial scan machine makes a mistake and doesn't match their face, CBP will just look at their green card and let them through. Technology errors aren't their fault, so it will be fine. That is a dangerous assumption. A failed biometric match, even due to a genuine technical error, triggers the exact same secondary inspection protocol as a refusal. CBP officers are not automatically authorized to override a failed scan. And if you become argumentative or uncooperative during the failed scan process, that behavior itself becomes a flag in your biometric file. Think about the situations where a scan could fail. Poor lighting, a new haircut, glasses you are now wearing, weight changes, aging, a physical injury affecting your appearance. None of these protect you from the secondary inspection trigger. And here is the critical part. If your scan fails and you are taken to secondary inspection, what you say in that room matters enormously. CBP officers in secondary have full authority to question you, review your travel history, and flag your file. A hostile or confused response during a technical failure can escalate a fixable situation into an immigration incident. The phrase you need to know: I believe there has been a technical scan failure. I am cooperating fully, and I am requesting to speak with a supervisor. I will give you the complete legal script for this situation in the Legal Shield section. People think they have their green card right there. Whatever happens with the scan, they can just show the officer their I-551, and that settles it. The green card is their legal right to enter. That is wrong. A green card grants you the right to permanent residence, but it does not override a failed or refused biometric check at a CBP port of entry. Under the new rule, your I-551 is step 1 of the verification process. The facial scan is step 2. If step 2 fails or is refused, your I-551 alone does not clear you. Officers can and do refer LPRs to removal proceedings even when they are holding a valid green card. This is the trap that shocks people most. They waive their green card. The officer says, "I see your card, sir, but you need to complete the biometric verification." The traveler says, "But I have my card." The officer says, "Step aside, please." And from that moment, the situation escalates. Here is the legal reality. Under INA Section 235B(1), CBP has the authority to initiate expedited removal proceedings against any person who cannot be verified as admissible at the port of entry. Admissible now includes biometric verification. Your green card proves your status. It does not prove your identity under the new biometric standard. Both must be confirmed. And for LPRs specifically, if CBP opens a removal proceeding and finds evidence of abandonment of LPR status during a reopened hearing, your I-551 can be revoked entirely. Not just your entry, your entire green card. Gone. People think that even if something goes wrong at the border, they can just come back another day and try again. It's not a permanent problem, they tell themselves. That belief could destroy their life in America. A biometric non-compliance entry denial under the new rule triggers a 5-year re-entry bar for LPRs under expedited removal. A second offense escalates to a 10-year bar. And if a removal proceeding is opened and abandonment of LPR status is found, your green card can be permanently revoked with no automatic right of return. Let me repeat that for the people in the back. 5 years. If you refuse a facial scan and are denied entry, you could be barred from returning to the United States for 5 full years. Your home, your job, your children's school, your life in America, locked behind a 5-year bar because you covered your face at a kiosk. INA Section 235B(1) is clear. Expedited removal proceedings can be opened against any LPR who fails biometric verification at a U.S. port of entry. A 5-year bar applies on first offense. A 10-year bar applies on repeat refusals. Revocation of I-551 is possible if abandonment is found. Now, here is what you can do. There is a legal pathway to fight back if things go wrong, and I'm going to break it down for you right now. Okay, you know the dangers. Now I am going to give you the exact game plan. Before the border, at the border, and after the border. The most powerful thing you can do is prepare before you ever set foot in an airport or cross a land border. Here is your pre-travel checklist. Carry your valid green card, I-551, and your foreign passport. Both. Every single trip. Make sure the photo on your green card actually looks like you right now. If your appearance has significantly changed, major weight change, surgery, new scar, carry a brief explanation letter. Download and update the CBP One app on your phone before international travel. Make sure your biometric profile is active and linked. Do not cover your face in any way when approaching a CBP kiosk or booth. Remove glasses if the kiosk prompts you to. Remove hats. Carry a printed copy of your I-551 biometric registration confirmation if you completed CBP One pre-enrollment. If your scan goes through cleanly, great. Cooperate fully, answer clearly, move on. If your scan fails, and this is critical, here's the exact script you use. Stay calm. Look the officer directly in the eye. Say these words. Officer, I believe there has been a technical scan failure. I am fully cooperating with this process. I have my I-551 and my passport here. I am requesting to speak with a supervisor to resolve the biometric match issue. That is it. Do not say, this is a violation of my rights. Do not say, I know immigration law. Do not become argumentative. Anything you say in secondary inspection can be documented in your biometric file. Calm, cooperative, and asking for a supervisor, that is your shield. If you are directed to secondary inspection for any reason, you have the right to remain silent on non-biometric matters. You are not required to answer questions about your finances, your political opinions, or your family member's immigration status. Let's say the worst happens. You are denied entry and a removal proceeding is initiated. Here is what you do immediately. You need an immigration attorney within 24 hours, full stop. But here is the legal framework they will use to fight for you. Your attorney files a motion to reopen with CBP's Administrative Appeals Office, the AAO, under 8 CFR Section 103.5. This motion challenges the denial on 2 specific grounds. Ground 1, technical scan failure constituted a procedural error that does not reflect willful noncompliance under INA Section 235B(1). Applicant cooperated fully and the denial should be vacated. Ground 2, if refusal was involved, applicant invokes Fourth Amendment due process rights under Matthews v. Eldridge, balancing test applicable to LPRs at ports of entry, and requests full evidentiary hearing before removal proceedings may proceed. Additionally, and this is guidance directly from the National Immigration Law Center, always carry a secondary photo ID. Your foreign passport with a valid visa stamp is your due process backstop. It demonstrates identity independently of the biometric system. If your scan fails, your passport photo gives the supervisor a manual override pathway. And one more thing, do not attempt to re-enter at another port of entry after a denial. Your biometric denial is logged across all CBP systems nationally. A second attempt without legal clearance escalates your case directly to the 10-year bar scenario. Here is what I need you to walk away with today. January 15, 2026 changed the rules at every U.S. border crossing. Your green card is no longer enough on its own. Your face is now part of your identity verification. And the consequences of getting this wrong, even accidentally, even because of a camera glitch, are not minor. They are a 5-year bar, a 10-year bar, potential revocation of everything you built in this country. The people being detained right now at airports are not criminals. They are not fraudsters. They are green card holders who simply didn't know the rules had changed. That cannot be you. That cannot be your spouse. That cannot be your parents flying in to visit. Immigration enforcement is moving faster than ever in 2026. New directives, new technology, new enforcement priorities. If you are traveling internationally and you are not staying updated in real time, you are operating with a blindfold on. That is why our free official WhatsApp channel exists. Every time CBP updates a biometric policy, every time U.S.CIS changes an entry requirement, every time there is an enforcement memo that affects your status, you get an alert on your phone, direct, instant, no algorithm filtering it out, no waiting for a news article. The link is in the description right now. It takes 10 seconds to join, and it could save your entire immigration case. Join before you close this video. Now I need you to do one thing for me. Right now, before you close YouTube, think of one person in your family WhatsApp group who travels internationally on a green card. Send them this video. Not tomorrow. Right now. It takes 3 seconds and it could stop them from being detained at the airport, from getting a 5-year bar, from losing everything. Hit the like button so YouTube pushes this to more immigrants who need to hear it. And if you are not subscribed, hit subscribe and turn on the bell notification. We cover every major immigration change every single week. You cannot afford to miss an episode. Last thing, if you have already experienced a facial recognition issue at a U.S. port of entry, or if you know someone who has, tell me in the comments below. I read every comment, and if there is enough demand, I will do a full dedicated episode on fighting biometric entry denials with real case examples. This is James from Immigration News Today. Travel smart, know your rights, and above all, stay legal.